Welcome to The Explainer. Today, we are diving into a really fascinating legal dispute. You know the type, a homeowner versus their homeowners association. And this case really makes you ask, when is an official approval not actually an approval? It's a wild story about a family who, they thought they'd followed all the rules, but still ended up in a massive legal battle over a wall they had written permission to build.
Okay, so here's the project at the heart of the whole thing. It's in the Arroyo Mountain Estate community. The homeowners, Rick and Elizabeth Goebel, wanted to make some pretty big upgrades. They took out a low, decorative pony wall and put in this very substantial 8-foot-high courtyard wall. A pretty dramatic change, right?
All right, let's look at the HOA side of things. They argued that this new wall was a straight-up violation of clear community guidelines, and their entire case really hinged on one very, very specific rule. Let's get into it. So the HOA's whole argument was based on this official violation notice. The key phrases you got to pay attention to are unapproved patio walls and in excess of the permitted 42 inches. It all comes down to a rule about something called a pony wall. So what in the world is a pony wall? Well, according to the community's own guidelines, it's just a low wall in a front yard, to create a little courtyard or a seating area. But here's the thing. The definition itself isn't what's important. It's the specific rule that's tied to it that matters. And boom, there's the number at the center of this whole mess, 42 inches. That's it, 3.5 feet. The Goebels' new wall, it was nearly 8 feet tall. That's more than double the permitted height, which in the eyes of the HOA board made it a crystal clear violation. No question about it. So when it came time to testify, the HOA's board president, John Consalvo, and a committee member, Judy Oliver, laid out their case. They basically said, look, the Goebels application was super vague, especially about the wall's height. The person who approved it thought it was just for landscaping, plants and pavers, not a huge structural wall. They argued that if the true 8-foot height had been clear, there's no way it would have been approved. And they made a big point that no other home in the whole community has anything like it. But the Goebels, they told a completely different story. For them, this wasn't about breaking rules. It was about following a process to the letter, only to be met with a shocking lack of communication from the HOA. And this timeline is really the backbone of their defense. The Goebels argued they did absolutely everything that was asked of them. They submitted their application, the HOA asked them to split it up, so they did, and resubmitted it the same day. Then on January 5th, they get an official signed approval for walls and fences, so they build the wall. It's completely finished by April 19th, but they don't get a stop construction notice until May 12th, nearly a full month after the wall was already done. Okay, and this right here is a crucial point. Mr. Goebel testified that his plans never once used the term pony wall. He specifically called it a courtyard wall. Now, why does that matter? Well, he pointed out that while the HOA guidelines are super strict about the 42-inch height limit for a pony wall, they have absolutely no definition or height limit at all for a courtyard wall, the very thing his approved plans said he was building. Interesting, right? This quote from Rick Goebel really sums up their entire defense. He's basically saying, hey, I don't know what else I could have possibly done here. He's putting the responsibility squarely on the architectural committee. I trust the people we put on that committee to do their job, to do their due diligence. In his mind, it was their job to review the plans and ask questions if something was unclear. So as it turns out, this whole dispute really came down to the testimony of one single person. And it was the very person from the Architectural Review Committee who actually signed off on the project in the first place. Her name is Nancy Razzo. And what she said on the stand was without a doubt the most dramatic and pivotal moment of the whole case. It pretty much decided the outcome right then and there. This was the bombshell. When asked about the plans for the wall, Nancy Razzo just admitted, with incredible honesty, I just missed it. Plain and simple. But she didn't stop there. She went on to testify that in her view, once the application was approved, that's it. The board couldn't do anything else about it. Okay, so you have these two totally conflicting arguments, and then this just stunning admission in the middle of it all. So, how did the administrative law judge rule? Well, the verdict was decisive. The judge ruled in favor of the homeowners. The HOA's petition was denied, and the judge found that the Goebels were not in violation. You see, the final ruling wasn't really about the height of the wall at all. It was about the integrity of the approval process. The judge's reasoning was actually pretty straightforward. Step 1. The homeowners followed the process perfectly. Step 2. The committee had plenty of opportunities to ask for more details but didn't. Instead, they gave a formal written approval. Step 3. The homeowners justifiably relied on that official approval to start building. So step 4, that approval basically acted as a binding exception to the 42-inch rule. And finally, step 5, the judge found that the HOA waiting nearly a month after the wall was finished to send a notice was, and I quote, unreasonable. So this whole case leaves us with a really provocative question, doesn't it? Does a simple oversight by a committee give a homeowner a permanent free pass on community rules? It's a powerful reminder, whether you're a homeowner or on an HOA board, that in these kinds of disputes, the process can be just as important as the rules themselves. In fact, it can be everything.